Good afternoon. It is April 2nd, 2020, and we're here today to talk about creative solutions for parenting time amid the COVID-19 crisis. I'm Liisa Speaker, your host today, and I have three wonderful panelists with us. First, we have Randi Pittler, who is a divorce attorney, family law attorney in Oakland County. His premise is amicable divorce, and he works with a lot of people where only one party is represented by counsel. So he has a lot of dealings with impropers in his cases. Another panelist is Liz Brandstorfer. She's a family law attorney in Grand Rapids. And she is also the current chair of our family law section. And I don't think she ever expected this year would be so crazy for her and actually have so few council meetings. Hopefully we'll be on a Zoom meeting for the May one at least, since we're canceling April. And last but not least, we have Shelley J, who is in Oakland County, friend of court. She is a custody and parenting time specialist. In some counties, we call that an investigator, but that's the title they use in Oakland County. So she works with a lot of, I would think a lot of impropers who are initially dealing with their custody disputes. So we're gonna, I just wanna go through a couple of the ground rules. I already mentioned keeping your phone on mute during this so it's not distracting us hearing the background noises. There's also a chat button at the bottom, and if you have questions, I will try to monitor the chat as the panelists are answering questions, and I'll try to incorporate some of the comments I see. But if you want to go back and look at the chat, and we're actually planning on looking at the chat after the fact, and to help answer questions that we didn't get to, I know Liz suggested going back and looking at the chat, which we can do with the recording, and try to share some of those answers on the family law listserv. And then I didn't come up with a poll this time. I did a poll last time, and I guess I just slipped my mind. I didn't think about it this morning. So we're not going to do any polls today, but that's it for now. So we're going to start with just having creative solutions. We're dealing with all these parents, and last week we talked about, what do we do with enforcing our parenting time orders? But hey, wouldn't it even be better if we don't have to enforce, because we're helping our clients come up with solutions with their ex-spouse or ex-whatever, the person with whom they have a custody arrangement, so that we don't have to have as many fights in court. So that's the reason I invited these three in particular, because I think they can really share some creative solutions. So Randi, why don't you start by telling us a little bit about, I know you've had to deal with some cases already. I think you mentioned 5 this week that you were dealing with, trying to help parents come up with solutions for parenting time right now.
Right, thank you. It's actually been like the last week and a half. It seems like I have 5 cases and they're all pending. So they're a little bit different, where none of them have existing parenting time orders. And I know Liz on our prep call yesterday did point out that the Supreme Court order does say that parties are supposed to follow existing parenting time, custody parenting time orders or agreements. So, I am encouraging people, if they do have a temporary agreement, to stick to that. I've had issues in some cases because they were doing nesting or other variations of kind of shared parenting, and they've lost like one of the homes that they were able to go to simply because there's an at-risk person in that house. So that's where a lot of my cases I've had trouble. The kind of general advice I was giving those people, and it almost seems kind of almost like a little flip or almost like condescending, but most of us know in most of our divorces, people were unhappy for a very long time. We all hear stories about, clients saying, oh, we've been roommates for the last 5 years, 7 years or whatever, but they still manage to co-parent civilly. So I'm kind of, and then they get into court and they file for divorce, and suddenly they're in like litigation or fight mode or strategizing mode. So I've been trying to encourage them to try and shift their mindset back to that time when they were able to just simply co-parent in the house, coexist civilly, and stop thinking about the court case. Because I keep seeing people trying to come up with a temporary parenting time schedule that they could later use in court. So I'm trying to discourage people, to change that kind of mindset. And because I don't think judges are going to give a lot of weight to what's going on right now because it's so unusual.
When you say give a lot of weight, Randi, are you referring to the fact that if the children are in one household right now and are pretty much staying in one household because they can't go back and forth, that the judge is not going to use that against the other parent, the one who has not had as much parenting time during the shutdown?
Correct. There's two things. One is that I mean, we don't know. There's obviously no case law, and we don't know what judges are going to do. But I would certainly hope most would, if parties had a certain kind of schedule and arrangement before that, and suddenly one parent has most of the parenting time or all of it because of COVID, that a judge wouldn't use that kind of to say, oh, well, now there's a new established custodial environment because this is new. But also in the fact if one parent, if they're not in the same household, and if one parent, or even if they're out of state, I think we're going to talk about that later, right, that they're not going to kind of use, if one, and I actually think it's going to be the opposite. I think if one parent intentionally withholds it when they don't need to, I would believe that most judges would actually really hold that against parties as someone who doesn't want to, be cooperative with parenting time and want to co-parent. So I think people, I'm trying to get them, I don't think any strategies during this period are going to be helpful.
Got it. Liz Brandstorfer, do you have any creative solutions that you've been able to impart to your clients or have been thinking about?
Well, first I want to say, I think what Randi meant about orders or agreements was the governor's stay home, stay safe order. The Supreme Court only talks about orders, but the governor's ban on travel talks about orders and agreements. So I don't think an agreement becomes more enforceable because of COVID-19 than it was before that, but I absolutely agree with Randi that courts are going to look at who acted in good faith. And from an attorney's perspective, the reason that I agree with him that what you're doing during COVID-19 is not likely to change or create an established custodial environment is because of the statutory language about the expectation of permanence. Everybody ought to know and ought to be telling their children the fact that you can't see mommy or you can't see daddy is only temporary because of what's going on, that you will get to start seeing them again. And that does kind of segue into what my ideas are, which primarily are based on the golden rule. Treat someone the way you would want to be treated. Don't ask to retain a child during the other parent's parenting time without offering them, here's what we'll do when this crisis is over. And don't expect them to be okay with maybe even a one-on-one kind of makeup situation if you know that you wouldn't feel that way yourself if that's what we're going on. There is a very small number of cases where the kids are actually in some kind of danger at the other parent's house just by being there too long. I mean, we have all probably had some clients where it's either our client or the other parent who has a mental health condition and they're great with little chunks of parenting time, but too much responsibility is a danger. Those are going to be hard. And those are ones where maybe the availability of the court for ex parte or emergency hearings might need to be invoked. But my ideas are generally use what the orders allow us to do. If you can't have parenting time at somebody's house, offer to take the kids to meet the other parent and go for a walk in a public park. I mean, they can spend some time together and then everybody can do the cleanup stuff before they go back into their environments. There are lots and lots of options, particularly on days like this, that it's going to be sunny and 60 degrees. Thank goodness it's not still freezing rain.
Thank you, Liz. And I, before I ask Shelley a question, I wanted to make sure everybody knew that there's a raise your hand function. If you hit the participant button down at the bottom of your screen, you'll see you can raise your hand, and then if I have a chance, then I can call on you if you have a question. Or if you don't want to raise your hand, you can use the chat function at the bottom of the screen and write a little message to me, and I'll be trying to monitor. I'm trying to monitor it as our panelists are speaking. So moving to Shelley Wine, I think it would be helpful just to know a little bit about what your job is, Shelley, and do you see more post-judgment cases? Are you helping parents reach a custody agreement like at the very beginning, at the onset of a divorce case, for example?
We see pre and post judgment cases, and we do ADR work. So our goal is always trying to get the parties to own their own lives, their own decisions, their own judgments. That's always our goal, and that will continue with this whole situation because they know their kids better than anybody else. They know their circumstances better than anybody else. Even on our Smile video, Judge Gorska says, you know, you don't want somebody in a black robe to be making decisions for your household. So that's always the precept under we meet with people. And then certainly we do have orders of reference where we're going to do the investigation, you know, but most of our work is more ADR, trying to help people come to agreements. And that will be the approach that we're going to take with this. And Liz, I liked how you said it, bringing them back to the fact that this is a temporary situation and that it's not going to be the permanent. And how do we talk to our kids to get them to understand this is temporary? And as we talk about best interests for children, certainly the health and safety of everybody is the best interest. So obviously the children's health, but also the parents. They need both parents. They get one mom, they get one dad, and we all need to stay safe. So keeping parents to focus on the best interest, but also Liz, in that temporary situation, she steps into what we would look at in the custody factors, which is to encourage and facilitate. So what kind of language are the parents using with the kids to encourage and facilitate? So you can't see mom or dad right now because maybe they've been exposed. But you know what, they still love you, and we're gonna find ways that you can still connect. So I love that the media, we have so much today that if this happened 20 years ago, there would be such a distancing that would be happening with families. But now we can connect in a lot of different ways. So making sure that FaceTime or Skyping is happening. You see on the news that kids are taking sidewalk chalk. So can we go by the other parent's house and we can draw pictures and leave little messages? There are just different ways that kids and parents can connect, and I'm grateful for that.
Now, Shelley, you mentioned something yesterday when we were chatting about an interaction with your granddaughter earlier this week. Why don't you share that? Because I think that's an example of something a parent could do with a child.
Right. So my daughter and her husband, they have small group time, and they've been doing it through Zoom, just like we're doing it. And so I get to babysit from afar, and my little granddaughter's 3 years old. And so we set up on both ends of the aisle there. She's in her home, and I said, well, how about we do Play-Doh this time? So I have Play-Doh in my house, and she has Play-Doh in her house, and we make little projects, and we talk about it, and we laugh. And of course, she's learning about colors, so we're mixing the red and the yellow, and we come up with orange. So, you know, you're learning and teaching, but you're connecting. And then we probably read 5 different books, and some rhyming, some things like that. And it's very special to do that. Although I would love to give her a big hug and a kiss, that is a really nice way to be able to do that. And I think those are examples that our parents can utilize to make sure that the kids are staying connected.
Randi Glanz, can you take mute off for yourself? I wanted to address your question to the panel, and it might be available. So Randi posted on the chat about a situation where mom wants to keep the same parenting time schedule that they've had before. The father wants to expand it. And the mom's concern, I think, right now is that now that this executive order has come out today that has some educational guidelines for the kids who are now finishing school from home, I feel like what Randi was saying, that she has even more of a reason, at least what she's arguing, to have the kids in her home so that she can manage the manage the educational requirements. Randi, did you want to add to that at all before the panel?
Yeah, I mean, this is just one of many examples that I think everybody's probably experiencing right now. And our job obviously is to try and keep things as calm and peaceful and reasonable, realistic as we can. In this case, I represent mom. And my suggestion to mom was, you know, maybe we lighten up a little bit more on the weekends, you know, extending them maybe from Thursday to Sunday instead of this. Father has a very old traditional schedule. And I have told her that, you know, I do believe it's important if you can maintain some type of, even before the governor's order today, normal consistency with the schooling especially, and in this case, there are younger children, be beneficial. I don't know that dad's ever going to agree with that kind of concept. He thinks timing and bedtimes, and everything should be loosened a little bit. And quite frankly, none of us really know the right answer to any of this. We don't know how this is all going to impact these families and their children, you know, and whether this is going to be, obviously with the new school ruling, that's one thing, but how long this is truly going to last. So, you know, one of the frustrations that I know I have is that this type of situation with, in this particular case, with dad talking to the kids and saying, I wish you could stay over, it's only because of mom. It's kind of a free-for-all. We don't have judges that are going to listen to these issues right now. These are not emergencies. And I do believe that we should reserve emergencies for truly emergencies. But I'm not so certain that we're going to have the consequences imposed in some of these cases. This is a minor one, but some of the other ones that I think are a little bit more.
You mean like the denied parenting time cases?
Correct. You know, I do hope that judges are going to try to really listen to exactly what's been going on and whether there was a good faith attempt. But we all know it's, you know, we're given 5 minutes in a courtroom to address an issue that occurred, and sometimes it could be maybe 2 months previously. So I'm not certain. I don't know if anybody else has a better sense of it. Maybe Shelley, you do because you're in the court system, but you know, how we try and convince our clients that, you know, we gotta look at the big picture, and we have to kind of lighten up a little bit and hope when all of this is over, we've learned a lot. We'll be able to manage these issues that come up in a better way. But you know, trying to convince the other parent or even the other attorney that your view is more reasonable than the other, it's challenging. I don't know if others are experiencing the same issues, if they have some guidance. I would certainly appreciate it.
Randi, if I can just jump in real quick.
Mm-hmm.
So Tim Cole from the state sent out an email this morning asking for ideas and how are we going to deal with these parenting time complaints, and can we encourage the people to not file the complaints but to try and resolve the issues, and maybe we can come up with some things we can send out as ideas on make-up parenting time. But I really liked when you said, what can we say to our clients? So for the court, we so appreciate you guys as attorneys that will talk to your clients and try and get them to reframe their thinking and refocus back into the idea of temporary, the idea of best interest, and how do we help our kids right now. The focus of this should really be on the needs of the children. And so I know the other piece is Oakland County front of the court, we are going to be doing way more joint meetings. So in the interim, we're here to help support. We're up and running.
Mm-hmm.
We're all working remotely. So if you run into a bind and you want us to help maybe be able to speak into your clients and just give them some ideas, please call. We have the numbers, we're able to access the cases, and then we can try and help simmer things down to the best of our ability. And I think that, you know, there's going to be frequent flyers, and they're going to be contentious cases no matter what. Before the coronavirus, we had it. And so I think we all can team up to help these clients.
Shelley, so you mentioned so I think you were referring specifically to your position as a custody and parenting time specialist are available to help the families get through this. And if other, I know we have a lot of referees on the phone. If you're from a different county than Oakland County, and you also have investigators or the parenting time specialist who are also available to try to minimize the conflict in court, feel free to raise your hand, and I will make sure you have a chance to share what's going on in your county as well. Liz, it looks like you raised your hand. Let me see. Liz?
Yep, I did, because I had an idea for this specific situation, which I think is pretty common. Mom wants to follow the order, which she's fully entitled to do. Dad has apparently now started complaining about following the order, which is a new thing because of COVID and the lack of school. So we talked about mom maybe being willing to offer him a little bit more time while the kids are off school. Mom could also say, as long as you stop telling the kids, I want to see you, mom's so awful, she won't let me come over, then I will allow you to have this extra time. And if we can do this for till the end of the school year, then maybe I'll make that Sunday overnight permanent, so that your alternating weekends are Friday to Monday instead of Friday to Sunday. So dad's got some incentive to behave better, because I do agree the judges are not going to want to hear stories or have motions about this person followed the schedule, but they groused about it to the kids. I mean, that to me is a manifest waste of the court's time. So that's one suggestion for how to maybe minimize the bad mouthing that's going on in one household. Hold out a carrot instead of swinging a stick.
Randy?
Yeah, and I think also there a lot of mediators now are doing, short Zoom mediations for these type of issues. I know in Metro Detroit, I've talked to a couple who are doing that. I know statewide, there was a group that put out a letter of doing these kinds of things. So that's certainly one resource if you can get both attorneys to agree, to do a 1 hour Zoom mediation. I have a case now in Oakland where it's not a child-related issue, it's a post-judgment issue, but the judge is basically referring the other attorney and I to the referee to kind of see if they can facilitate a settlement of our issue so we don't have to take time for a motion hearing. And so perhaps, I know the court staffs are kind of already overburdened and it's hard to work from home and with limited staff. But, perhaps that's an option if like each court could have like maybe a friend of the court counsel or referee available, like they rotate one day where people maybe can call in and the two attorneys spend 15, 20 minutes on the phone to maybe try and come up with creative solutions. Because, again, this is new ground, but we're probably going to be here. The governor's talking about extending the stay at home for another 70 days. I mean, this is going to be our normal for at least, 2 or 3 months.
Right. One of the questions that came up on the chat had to do with do we treat our time right now because school's not out anymore? Do we treat it as a summer schedule or is it still the school year schedule? And my instinct is, and I would like to hear from the panel if you agree or disagree, is that it's still the school year schedule because the kids are required to do things educationally. And so I think that school year schedule would still apply, but I mean, there might be a way, and of course this takes the parents who are never going to get along about anything. It's just not going to, I mean, I don't know how much we can do to help them, but the parents that maybe, even if they have a tense relationship, but can try to work for the best of their children, they might be able to do something like, especially if there's multiple children, maybe dad can be on the phone with one child helping with homework while mom's in another room helping another child with their schoolwork, because I know I have 2 kids at home and it's like you can't be working with 2 kids at 2 different grade levels at the same time in different rooms. And maybe there's a way that the parents can work together to try to help their children with their educational instruction, even when they're in different houses.
Yeah, I agree. Go ahead, Randy.
Jump in just real quick as an aside. For our school district, for example, spring break is next week. I was supposed to be on a plane today to California with my kids. So I have a feeling we might all be getting phone calls tomorrow or Monday about, hey, it's spring break, but there's really not a spring break. And again, that's just another area where people need to communicate.
Right, and we did. So when this all hit, the calls came in and we actually issued a standard policy in ours is that we were going to just follow whatever the school calendar is, it's still in place, and that spring break would still be those dates. Unless they want to determine and come to agreement otherwise. One of the suggestions was maybe make Memorial Weekend longer or maybe do an extra week in the summer or something. I mean, certainly whenever people can make their own agreements, that's going to go better. But we are still honoring, as far as I know, and we haven't gotten a new email today saying otherwise, we're still going to allow it to be the school year to be according to what has already been issued.
Right. Liz?
Yeah, the courts I have heard from have all done the same thing. They've said it's spring break, follow the school calendar, even though the kids aren't in school. When I was asked before about, is it now summer because school's not in session, I said, I'm sure they're going to do the same thing. I mean, of course, there's a possibility that they won't, but I'm sure that they are going to just look at your same school calendar. I also encouraged parents, if the point of spring break is travel, then talk to the other parent about swapping. Do your normal schedule next week because nobody's going to travel. And then whoever gave up their spring break week, pick a week near the end of the summer that maybe you can travel to do that kind of spring break rather than skipping spring break this year and moving it back a year going forward, although that's an option as well. And I love your idea about, you know, let's kind of maybe look at Memorial Day weekend, you know, as another way of allowing some extra time for what's been missed.
So I wanted to turn our attention to some situations where the parents have a little bit of a trickier situation. And one of the examples we wanted to talk about today was when the parents live in different states. And obviously that makes parenting time a lot more complicated to have in person, even when it is permitted to transport a child for purposes of out-of-state parenting time, according to the governor's order earlier in March. Any thoughts? I know there's been some comments about one parent not wanting the child to leave the state due to the high risk of traveling. Panelists, do you have any suggestions for parents who are living in different states, how they can have any kind of in-person parenting time during this situation?
Well, I mean, to me, that kind of dovetails in with the whole spring break situation. You might decide to swap it out for an extra week in the summer. The other thing I would say is you need to look not only at the law of Michigan, but at the law of the other state. Maybe don't advise your client to let the child go without doing some investigation about whether or not they're going to be allowed to come back. The other thing that's happened in one of my cases that's kind of related is that mom has decided that she's moving herself and the child to somewhere else. They're not going to stay here. They're going to go where she has family support. Now, my client lives in Canada, actually, and so he wouldn't have had any in-person parenting time but for spring break, which he gave up a while ago, knowing that he wouldn't be able to travel for spring break. But we do have to consider those domicile issues. You can't move more than 100 miles. You know, how much I'm going to go live here for 2 or 3 months. Do we put up with? Do we worry that she's going to be job hunting while she's there? You know, I mean, one hates to wish for bad news and conflict, but it is, I think, something worth thinking about before you consent to something that seems reasonable, is making sure it's limited to just that.
So Liz, you bring up a good point. So if a parent, the example you gave, the parent wants to go be closer to her own family in a different state, if that's the intent, just to do it for the time of this crisis, if that's what the stated intent is that really changing the child's residence under 722.31? If it's intended,
no,
but
you know, if you get there and you can find a job there and then you decide to stay and then you find the motion, then you file the motion for change of domicile in 2 or 3 months, you know, it does need to be, it's something we have to think about for high conflict families.
Melissa Pierce, you mentioned that some states are barring entry to residents of other states. Do you happen to have any examples of where we may not be prohibited, we may not be able to travel? I'm gonna give her a second to take herself off mute. Okay.
Yeah, Lisa, so I'm hearing like we have family in Texas, and Texas right now is barring entry to anyone from these hot zones, so Michigan is one of them, from entering their state because they don't want the virus being brought into the state from someone out of state. So I think it's really important to look. I know Florida is doing that specifically with New York and New Jersey states, but to really look at the state the other parent lives at and what are those executive orders about non-residents coming to visit.
Got it. And Evelyn just mentioned that Florida is doing the same thing if they're coming from a hot zone. And so is the hot zone basically the top 6 or 7 states that have the highest number of diagnosed cases?
I think you would have to look at it. Like, I know I personally live in Oakland County. We're near that hot zone for Michigan, but somebody in the UP or, on the west side may not be, in a high impact. So that's something that you have to look at and discuss with the other parents, and find out, what is available, because, it's not going to make any sense if the child's got to go there and quarantine for 14 days.
So trying to come up with creative solutions panel about parents living out of state. Maybe it's not feasible for the child to be traveling out of state right now. What kind of solutions do we have for that parent? What if that parent wants to come to Michigan to exercise parenting time? Are the hotels still open in a limited basis where they could get a hotel room at somewhere nearby the custodial parent's home and have some time with the child in the setting of a hotel, rather than, of course, this requires them to have the resources to be able to do that. But do you have any ideas, Randy or Shelley, Liz?
Yeah, my understanding was, I did think, and I could be wrong, I thought I read that hotels were, it was up to the hotel, but that, they had to be maintained with a very, a skeleton, only the essential staff in the hotel so people could stay. To me, it's a matter of, right, what state are they coming from, and also how far they have to travel. I think, putting a child on a plane at this point is probably, a little risky. So then it's a matter of how far can you drive without too many stops along the way. I know, I have a case where there was a parenting time where my client lives in South Carolina, and fortunately the parties agreed that the child would just simply stay there, even for spring break, when the father and the father in that situation would go down and actually spend the week there. And he's chosen not to do that because of the safety issues. So I think it's a matter of coming up an agreement, what can work best, again, for this time for the child's safety, not just for what's in their best interest. But I do know anecdotally, there was, I think, the one Oakland County case where a judge said a child did not have to fly to Florida for parenting time. And I did speak with an attorney this morning who had another Oakland County case where his client, the child lives in Windsor, and the parent in Oakland County was being denied parenting time. And it's the same thing at the border. I think it's a 14 or 15-day quarantine. And so that's just not feasible. So I think you're going to have to go back to what Liz was saying, is either doing it remotely and try and come up with make-up parenting time whenever it's available.
I think one of the things that Liz mentioned earlier, and if it wasn't today, I apologize, but what we should be doing right now is having our clients come to an agreement now about, if you're not getting the parenting time that you are supposed to be getting under the order for whatever reason, it may be because you're out of state, come up with an agreement now about what that parenting time, make-up parenting time will look like. Liz, did you want to add to that, or Shelley?
I would just add that come up with that agreement and exchange emails, not just text messages, because of how much easier they are to use as exhibits if somebody denies it later. But document what that agreement is, and if it's got contingencies in it, spell those out. I mean, as attorneys, we have an ethical prohibition against speaking or writing directly to an opposing party who's represented by counsel. So you can't ghostwrite your client's emails to their co-parent if the other person is represented without keeping the attorney in the loop. So be careful of that ethical thing. But do help make sure that all of the necessary details are in the communication, again, particularly with those high-risk parents or those high conflict parents.
Yeah, I agree with that, Liz. Those agreements, when they do that, because it can often fall through, especially when they're stressed. So everybody is under stress right now. This is impacting every person, whether we're knowing it now or not. It's all going to be there. And so decisions can be made quickly, and they are maybe misinterpreting what they're agreeing to, and so can have some issues. So definitely emailing. We use a lot of Our Family Wizard, which is helpful for us too in that. And Randy, I'm in agreement. I think that out-of-state travel right now, and because we're still climbing on this, we had a case about 3 weeks ago, I think at our last motion call, which was about travel to, I think it was to California via plane for twins to go, and it was denied at this point. And then there was the offering up of make-up parenting time I just think that the health and safety has to be the first piece. I mean, that's the baseline of best interests, and then we go up the hierarchy of needs, but certainly wanting to preserve and protect. But I like that upfront offer of, so I get that you're missing, and honoring the fact that it's hard to miss that parenting time, right? And so to say, I care about that. So how about we make sure we're providing an agreement as to when you get to have that again. And maybe even a contingency, because it's still moving. Like, we thought we were going to be out of quarantine, and now we're looking at 70 more days. We're all going to need help.
Right.
Can I jump in about the interstate travel just a minute, though?
Yeah.
Because there are an awful lot of planes that are flying with not very many people on them. I don't think riding on an airplane that has 20 people on it is particularly more dangerous than walking into a Myers store that has 100 people in it. And we're doing that all the time. So I wouldn't immediately say flying is a risk no matter where you're going and no matter what the details of the flight are.
Yeah, good point, Liz. Kimberly Grover had a good question on the chat about, couldn't the parties draft or the attorneys draft a stipulated order that all the parties sign and then get it entered later on? And I think the answer is yes, because agreements in writing can be enforced in court. You either have to have an agreement on the record or in writing. So even if it's not a stipulated consent order, it could just be an agreement in writing that the parties have signed. They could then be bound by it in court later on. I guess my thinking would be having it called a stipulated consent order. Really, it has the indicia that the parties intended it to be entered as an order. I don't know if that really makes a difference, but I'm happy to hear what the panelists think about that.
I would think that if you sent in a stipulated order, the judges would sign it. I mean, it might take a week or so depending on when your judge rotates through their day in the courthouse, but I don't think that consent orders are not being entered.
Shelley Kester, do you want to take yourself off mute for a second? And she provided an example where she recently obtained an ex parte order because the child would have to travel to Texas, and the parent is in a high risk occupation. So she obtained an order, this is not by an agreement, that there would be no parenting time right now, but then there would be that the parent would get 100% makeup parenting time once the shelter in place goes away. Shelley, did you have anything else you wanted to add about that?
She was in Texas. Her household was 100% compliant with the stay safe, stay home. They had reduced positive COVID cases in Texas at the time. They had one family member who was going to do the shopping and the necessary things. They were wearing a mask, wearing gloves. They weren't having the child do other activities in other households, and they were providing daily FaceTime. And then she was going to pay 100% of the cost to travel back for parenting time at the end of it. So there was no denial of the parenting time. And I learned a lot from the seminar that you first did, which I incorporated all those good suggestions into my motion, which had I not done that, I probably wouldn't have been as prepared with foresight. And that really helped me with that motion. I've subsequently got another motion that I think it's really important that it not come across as a means to deny parenting time. This one is going to be to request a parental preference, mutual parental preference, because there are ill people in the household, but not with COVID, but are vulnerable. And one of the parties is using childcare providers since their childcare is out, and they're refusing to say who it is, and they're not letting the other parent provide the childcare. And so from a safety standpoint of having each parent be the parental preference on an interim basis, not ongoing during COVID, I think also has a good chance of being granted because of the household risks.
So two things, if you weren't able to attend last week's webinar, it is recorded, and we did put out a link of the recording, but if anybody that's here today did not receive something inviting them to take a look at the recording, let me know, just put something in the chat button. We'll make sure Delaney, my marketing assistant, gets that out to you if you want to find out some of the helpful tips tips that Shelley used in her successful motion. And then the second thing, it had to do with the FaceTime. So, you know, FaceTime, Skype, Zoom calls, whatever with the children, even before this crisis, as an appellate attorney, I would hear a lot of complaints about one parent hovering over another, or you could hear them talking in the background, directing children, which, you know, I'm dealing with more of the high conflict divorces or custody cases. So if you have two parents that are willing to get along, daily FaceTime would be great. I'm not sure how that really is going to play out logistically when it's already a high conflict custody situation, but let's talk about that. Shelley, do you want to pipe in about having the video parenting time?
Yeah, and we are still going to have those cases where there are high conflict, and we're going to have the accusations that the other parent is interfering might be true. We might have a parent that is interfering. Those are the cases where I try and have a conversation with the parent that would be facilitating the calls to give them that thought process. Like, this is not about you. This is about the child and the parent having, and it goes back to encouraging and facilitating. And how is that best for the child? I think that part of my goal whenever, whether I'm doing it in the SMILE program or I'm meeting with parents, is to get them to focus on the children. Literally put a picture of your kid's face in front of you so you don't even see the X in the visual, because it's about your kids, and the kids have the right to parenting time. And when you redirect it and say, this is how it's going to help calm the waters for the child, and what happens, I mean, so we got a lot of anxiousness going around with everybody. Certainly the children are. So things are changed. How come I can't see that parent? This is a very important part. And if you can tell the parent why, it'll help the kids, right? So the kids might be acting out more. So this might help settle them, because this is a place where they can connect with that other parent and realize that other parent is still there, still involved, and still loves them. So I just see the value of trying to educate the parent who needs to facilitate.
So you mentioned the parent who's facilitating the FaceTime or whatever. I mean, I can understand if it's a very young child that the parent's going to have to be in the room, but why does, like, if you have a 3-year-old, 4-year-old, 10-year-old, why does the custodial parent need to be right there in the room with the child? Why can't they just leave the room and let the child have a private conversation?
For sure. And I think that's a part of the educating part. You can help set it up, but you can leave the room and let, like my 3-year-old granddaughter, mom and dad weren't in the room.
That was what I was wondering about. And where they probably had meetings to go to, and they're like, oh, great, grandma's here.
Exactly. So to go off and understand that this is their time, and encouraging that, and understanding that they don't have to be present for that moment. And obviously for littles, you know, you have a 1-year-old, you have a 2-year-old, they're probably going to need that parent there, and you're hoping that they're going to do that well.
Randy?
Yeah, I don't know if I really have anything to add to that one about, again, it's like parents have to try and be cooperative. I think what Shelley said was right. I did want to kind of back up to what Shelley said, though. I was a little concerned when you said the order for makeup parenting time would give the non-custodial parent 100% makeup parenting time. And I think that's something that we need to start looking at in terms of, if this thing ends up lasting for 4 months, say, it's probably not going to be legit, feasible to give somebody, 100+ days of makeup time when this is over.
Well,
so
that would be for a parent like who has 50-50 custody, right? But if the parents are getting every other weekend, it's not going to be that's what I'm thinking.
Right, but I think we just need to be careful not to lock in a very specific makeup schedule just because there's too many. Then we're going to get in trouble with another unknown in the future that maybe loosely worded in terms of the intent of the parties, or try and say this is kind of maybe this is the baseline. And then depending on certain, the intent is 100% based on the school schedule, the travel schedule, COVID, and everything else.
Shelley, were you trying to raise your hand?
Yeah, I'm just chatting. I have to confess, I didn't propose 100% makeup, but the judge included that in his order.
Oh.
But I think also, I am a little Irish, but anyway, I do think you could just file an ex parte motion, or a motion. If it got really crazy, you could file a motion to address it. And now that courts are really amping up with Zoom, I think you could address it if it went really long. Because I think a judge is going to understand, most judges, if it were to be that so lopsided, so that, I mean, one parent's going without for a long period of time. So I guess the mental health professionals could advise, like, how good is it for a child to have an extended period with one parent and then have to have an extended period with another, time with another parent? They all present their own unique facts. But the judge in my case thought it was appropriate for 100% makeup, given at that time it was going to end shortly. So.
One thing about the FaceTime or Zoom, I'm not sure how it works with FaceTime, but one issue that's come up is one of the parents, the custodial parent, recording the parenting time session by video, which could make the other parent feel pretty uncomfortable. I know it's easy to record on Zoom. I'm not sure if that's the same with FaceTime. Is that something that we should be addressing, and whatever the agreements are, whether that they can be recorded or not? Liz?
I would say the parents should talk about it, because honestly, if the custodial parent records it, they can play it back to the child if they're missing that other parent, sometime in the future. So I would encourage people to talk about it and see how it goes.
Okay. Any other thoughts about and part of the reason I wanted to talk about video parenting time is for those parents who have the unfortunate situation of having supervised parenting time. So having the shelter in place is causing a lot of problems with supervised parenting time. And I know it's a big issue in the child welfare area with DHHS not doing any of the supervision anymore, but also in the family law cases. We have places where parents would go to have their supervised parenting time. Facilities are closed and the workers are not coming in. And so those parents who already had very limited parenting time, maybe a couple hours a week, are not getting any time at all with their kids right now because the facilities that they go to are closed. Have any of you dealt with a supervised parenting time situation in the past few weeks?
Well, I it wasn't my case, but I was consulted by an attorney who had a case where that was the situation, and we talked about, are there other people who would be willing to do it? And in that situation, they didn't feel comfortable with a grandparent because they were afraid they wouldn't actually supervise. Mm-hmm. So my idea was reach out to the daycare centers and find out if somebody is willing, somebody who's not working because their daycare center is closed or has a smaller number of children, see if you can hire somebody who would do that work. I would think that would fit under the essential services because it's allowing compliance with a court order. And if both parents agreed on it, that might end up being something that could work for a family.
Yeah, I agree with that, Liz. Other avenues might be some of the universities where you have your master's level students for mental health who are looking for hours, because you can still do the social distancing and still do a good job supervising. You're still in earshot, but everybody's safe. So I think that is a good option. And I think it needs to be. We did have a remote case last week where we're trying to get the parties to agree on a supervisor. And it took some time to finally to get it there. And I think it also depends on what are the reasons for the supervision. So if you have a mental health issue or, a parent who has an addiction issue is different than a violence issue. So I think that it just goes case by case, and can we get it to a place where they can actually have an agreement in regard to that.
So Shelley, with the example you provided, was the person that was going to come and supervise doing it at the parent's home, the non-custodial parent's home?
No, it's going to be like at parks, just like Liz had suggested, okay. and try to the best of their ability to do the 2 hours a week offsite. And they were able to finally identify a person that they could agree to. Not a family member for the very same reasons you suggested, where you can't count on the grandparent to actually do the supervising appropriately. So. But yeah, I think there are people out there that are still willing to do it. We have a list of resources. So I think that for people who do it in the community, and I think that's important, and it is limited right now, because what are you going to do? I mean, we can go to parks. You can't go to restaurants, so a lot of walking, and you know, maybe there's a place in a park you could bring a ball and kick a ball, or you could play a game at a picnic table, or thankfully we're coming into a springtime where we're going to be able to be outside.
Great. And you said you have a list of resources. You mean like the friend of court has it for their own use, or is that something that's publicly available?
It's not publicly, but certainly if we get calls from
Okay.
attorneys, that we can give names of people who we're aware of that can do supervision.
Excellent. So it's outside of people that are outside of the facility situations.
Yes.
So another thing I wanted to talk about before we finish up today is what if a parent, you know, doesn't want to do parenting time right now? Maybe they're fearful. Maybe it's legitimate. I don't know. But for whatever reason, they just don't want to do parenting time right now. They want the child to stay in the other home. When this is all over, what do we think is going to happen? Are they going to be denied makeup parenting time because they refuse parenting time? Just putting it out there. Liz, do you have any thoughts about how that might be handled?
I think that if they just refuse and don't say anything else to the custodial parent now, they're not going to be entitled to makeup parenting time. I think if they have, you know, if a parent lives with an elderly grandparent, or their new housemate is going through chemo treatments, so even the risk of having the child in and out is one that they're not willing to take. I think they need to ask if the other parent now, if I don't have my time, but I do Skype with our child, if you will agree that I can have parenting time in the future. And if that parent says no, even knowing the situation, then I think that is a basis for a motion to modify parenting time for some period of time when the crisis is over. Certainly probably doesn't hit a Vodbarka standard for change of custody, but it seems to me that it would hit a shade standard for modification of parenting time, as long as you asked ahead of time and explained the reasons and made a reasonable proposal. Because one of the things that I think everyone on the panel agrees to is that if you act in best interests now, if you act in good faith, if you try to come up with something reasonable, you are much more likely to have success at a contested hearing when the courts get back to normal.
So here's one of the things I wanted to talk about. When I think part of this whole purpose of today's session was to try to give attorneys ideas of helping their clients come up with creative solutions to parenting time, so that we don't clog the courts either with motions now or when everything resumes back to normal. But what do we do as attorneys if the parent, one parent is rejecting creative solutions, and you know, you're an attorney, you're coming up with these ideas and your client's on board, but the other side's just not willing to budge on anything? I just would like some, you know, helpful tips from our trial attorneys about what you recommend your clients do, so that to make a better
Liisa,
motion.
you froze.
Oh, can you hear me now? Am I back?
Yeah, I can hear you.
Okay.
I can hear you.
Okay. So any suggestions that the trial attorneys can give to their clients now, so that when it is time to file a motion for makeup parenting time, that you have a stronger case, that you really did truly intend or try to make up some creative solutions, and the other parent just wasn't willing to cooperate at all.
Right. And that's where I think what Liz said is important, is document, you know, it should be in an email. Right. As long as you articulate, you know, a good reason, a legitimate concern, you know, and a reasonable proposal. And then if the person rejects it, at least you have that evidence to take to court and file a motion. And I get the sense, though, the courts, you know, I think motions can still be filed. I know they're not, in a lot of courts, they're not being scheduled. But, you know, I get the sense that most courts are trying to get up to speed and using Zoom quickly. So I don't know if it's going to be very long where we're going to be able to hear these motions heard. So I don't think we're necessarily going to have clients waiting 2 months of documenting these kind of, you know, denials of parenting time before they can get in front of somebody in the court.
Erica Salerno, can you unmute yourself?
Yes.
All right, I just saw you posted something, and we do have a couple more minutes, so I wanted to make sure I gave some of the people here a chance to talk. And you were stressing it's time to focus on mediating using a parenting coordinator. Can you just elaborate what your thoughts are?
Well, I mean, I primarily work in Kalamazoo County, and our courthouse, I believe, is literally shut down. It is locked. You can't even file a motion except by mail, and we've been told not to even call. So for us, I feel like there really isn't any other alternative other than to possibly use some form of ADR, even if it's arbitration by Zoom, something so that we can get some of these situations resolved, particularly if we're going to see extensions into mid-June.
So Erica, are your judges in Kalamazoo County they haven't even done a Zoom hearing or anything like that?
No,
Because
nothing.
it seems like I mean, maybe they're trying to figure it out, and I understand that, but it seems like Tom Boyd, the new administrator for the State Court Administrative Office, and the Supreme Court were very keen on making sure the courts were still operational, even if it's on a limited basis. That there's many courthouses that they have a skeleton crew. Judge Cunningham was with us last week. She has to go in for hearings that she does by Zoom, but she goes into the courthouse to do those. I know Judge Valentine in Oakland County, I heard, is doing a lot of Zoom hearings, and she can do them remotely, but one of her staff has to go in and be in the courtroom to start the hearing. But it seems like all over the state, courts and their staff are figuring it out. I just a little surprised at Kalamazoo County, which I felt like they were doing e-filing a long time ago. I was surprised that they hadn't figured out something yet.
Yeah, actually, we don't have e-filing available.
Sorry.
No, that's okay. But we do not. They're basically shut down. And so I think for our clients, fortunately, we have a very good collegial bar. So if we have somebody that's not in pro per, I think we're able to work together. And I'm actually one of the mediators that's trying to get all of our local mediators together to offer Zoom to people, but we really don't have a viable option for these high conflict situations, because in my mind, we've been actually told by our judge when he sent out the email that closed things, that it better be an extreme urgent matter, even on an ex parte basis. And so I'm sure there's a little bit of reluctance by many of us to even file an ex parte right now. And even stuff that I've filed by mail, it's not getting scanned into our Odyssey system or anything. So it's sort of a weird situation. You almost feel like a phantom.
Well, I know Sean Cook circulated something on the Family Law Listserv yesterday about encouraging people to use mediators. And I think there was a list of mediators. I'm not sure who was involved with that. Unfortunately, I didn't take a look at it, but I do have the email I saved. I haven't deleted it yet. But I think really the point is, this is the time to encourage our clients to work things out through the attorneys, through the mediators, whatever the case may be, without involving the courts to as far as you can. Because some counties you're just not going to be able to get into court. And I hear from Dan Fricke that Kent County's not doing Zoom yet, but they are doing phone. Are they doing telephone hearings? Liz, do you know about that?
No, everything I've had has either been decided on paper motions or adjourned so far.
Huh. Okay.
I haven't had any hearings in any of the counties I've been at by phone, except for Judge Cunningham and Eaton did have a pretrial conference by phone.
Right, and she's starting to use Zoom for hearings as well. And if Dan wants to unmute himself, he can share his experience if he did a telephone hearing. I'd be happy to hear about it.
Yeah, I got really lucky. I just happened to catch Judge Zamitis on a day that he was in, and I did a pro con over the phone. I was shocked I was able to squeeze that in. Maybe it was a struck of luck, but the neglect and child protective proceeding stuff, they were doing it by phone at first too, but everything's changing.
Right. So thank you, Dan. I guess one thing I'd encourage people to go back and watch the webinar from last week if you are contemplating doing a motion, because it sounds like some counties are definitely more equipped to handle those motions. I've been told they're supposed to be willing to accept motions and pleadings by mail, by fax, all the different ways, but it doesn't sound like, with 80 83 counties in the state of Michigan. We're not all at the same place yet. And with at least probably another 2 months of looking at this, I think some counties are going to have to figure it out if they haven't already. But I wanted to thank our panel today. If you have any last thoughts, we're right at the 2 o'clock hour, but if you have any last thoughts from the panel, I'd welcome you to say anything. Randi, Liz, Shelley?
I just think, go ahead. I just think that it's really important that we try and get our clients to see the reality of what we're in, and that this is a much bigger situation and it's not going to last forever. And how do we get them to come to agreement? Because it's going to be better if they stay.
Oops, sorry. I messed up. Can you unmute yourself, Shelley? I'm so sorry. I pressed the wrong button.
Okay.
Sorry about that.
No, that's all right. So I just think that that's the most critical thing, is really us as court officers to be able to really work with our people and try and get them to come to agreement and to own this to the best of their ability, because that's going to be the quickest route for calm, and it's going to be the best route for them and the kids.
Yeah, and Lisa, the thing that I would say is that the little bits of technological stuff that we're all learning because of these webinars, we need to try to figure out how to do that when we're at a court hearing, and how do you prepare your client for a hearing when you can't just look over and talk to him or her, or they can't pass you a note. Those technological skills that I, for one, avoided getting are now things that we're all going to have to learn. And me put my plug in for joining the family law section, which you can do at the State Bar website, and then sign up for the listserv, because there's a ton of just helpful information on technological stuff that's available that way.
Thank you. Randi?
Just that, you know, at the top, I don't know if people joined late, that I did mention there are a lot of mediators who are working to kind of facilitate some of these issues. So I think that's a great way to go until we get it figured out. And I also just hope, you know, obviously we need to be patient as the courts are getting up to speed on how to make this work. But I'm also hoping, you know, that this could maybe be our new normal, that maybe we could be doing more things by video or by phone in the future. I know in Out County, they have already done a bit by phone, where in Metro Detroit, we don't. And the comment I always make is my son, for people who've met him at family law events, we adopted him, and he was in, you know, he's from Indiana, and his mother and I, we never stepped foot in a courtroom in Indiana. We adopted a child by phone. So my feeling is, if I can adopt a child by phone, there's a way to do some of these simple hearings by phone without making us come into court. So hopefully this will be kind of a transition to a new way of practicing.
Thank you, Randi. And thank you to all of you for joining us today, and especially our panelists. We couldn't have done this without you. We are doing another webinar next week on child support issues, and we're going to have Kent Weichman from Wayne County. We're going to have an analyst from the Friend of Court Bureau at the Hall of Justice, and we're also going to have a Friend of Court personnel from Ottawa County. So stay tuned. You'll be getting an announcement about that in the very near future. Thank you, everybody, for joining. I'm going to stop the recording, and I hope you guys have a great sunny afternoon. Bye.
Thanks.
Bye. Thanks, Lisa. Bye, you guys.
Welcome.
Thank you.